Hey everybody, Paul Rabalais here. Welcome to our YouTube live stream today, December 22nd, 2023. We're going to talk about unraveling the estate and gift tax laws, but we're going to talk about it on a much bigger picture, not only the estate tax law, the gift tax law, but all other tax aspects of estate planning that really affect everyone: capital gains tax, income tax. We're going to hit it all. All right. Quick intro. Who am I? My name's Paul Rabalais. I've got 5 adult kids in their 20s and 30s. The oldest 3 are already lawyers. The other 2 are in law school. One's married to a lawyer. One's married to a doctor. So a lot of lawyers in the family. Tried to talk them out of going to law school, but they didn't listen to me. So been an estate planning attorney after going to law school myself, and then going and earning a master's degree in tax law from Boston University 30-something years ago, and worked for some big firms for about 3 or 4 years, but really the last 25, 26 years or so, I've been working as kind of my own firm, helping thousands and thousands of people get and keep their estate legal affairs in order. Since you're watching this, you may have watched other videos, another one of the, or several perhaps, of the 700 or so other videos that I've put on YouTube. Got a lot of response to that over the years. And since so many people from around the country were asking me to help them get their estate legal affairs in order, I formed a national estate planning law firm. It's called America's Estate Planning Lawyers. Links in the description below if you want to find out more about that, or even request a time to have an initial discussion about how your estate plan can be customized to make things easy for your family. So between myself and the other attorneys who work in my firm and the co-counsel arrangements we have around the country, we're able to help people all over the country get and keep their estate legal affairs in order. Okay, so a couple of ground rules before we jump into the good stuff. One, I would say, we've already hit a couple of comments, but go ahead and I'm curious as to where you are. So if you could just put your city and state, or just your state, or quite frankly, if you're not in the United States, put what country you're in the comments below. And that'll kick off some chat, and it'll pique my interest on where we're getting people from. But the real purpose of the chat and the real value comes from you sharing your prior experiences as it relates to the topic at hand. Even as you ask your questions, I'm going to guess that if you have a question, probably somebody else watching has the same or a similar question, or maybe someone who watches a recording of this on YouTube months or years from now will also have the same question. So at the end of the material that I present, I'm going to hit that chat, and I'm going to hit it hard. And I'm going to go through them one by one. And of course, all the appropriate ones, I'll be happy to do my best to answer those questions and have everybody get value. That's the whole value of the live stream, is it gets to be interactive. Okay. Let me just see a couple before. There were a couple, but before I even jumped on here, MG asked, for unmarried seniors with joint ownership in common of a house, do you have any suggestions for a living trust? Okay, so if there's unmarried seniors with joint ownership in a house, again, I have to make some assumptions. I'm guessing those unmarried seniors may, at least one, if not both of them, have children from a prior marriage or relationship. So when that's the case, and you have 2 seniors who have different beneficiaries or different heirs, it's kind of a no-brainer where each spouse, or not spouse here because they're unmarried, each person does their own living trust. And each person can name their significant other as some kind of beneficiary to that trust. And then each of them puts their 1/2 ownership interest in that house in their trust. So you often, with unmarried people, particularly if they have different beneficiaries, even if they jointly own a house, you often see them each set up their own trust and put their 1/2 interest in their trust. So that's my best answer based on the context that I'm reading. All right, let's see here. Can you talk about generation skipping transfer tax? Yeah, I'll hit on that. Washington, Texas, Florida, Kansas, California, awesome. Colorado, Michigan, good. Mississippi, Florida, a bunch of different states. Fantastic. All right, let's jump right in. Maybe to the person who asked if I would address the generation skipping tax, mouthful, generation skipping transfer tax. What is it about the generation skipping transfer tax that you'd like to have addressed? And if not, I can just address it in general. Let's jump right in, first of all, to the federal estate tax, because we're going to be hitting the estate tax, the gift tax that don't apply to everyone. And then we're going to be hitting on the capital gains tax and the income tax that do pretty much apply to everyone. Okay, the estate tax, going through some changes in, I guess it's going to be 10 days. Our estate tax exemption, the amount that someone can leave to their heirs when they die without the 40% federal estate tax applying, that amount increases on January 1, 2024 from somewhere around $12.9 million, 12.91, I believe, to $13.61 million. So big jump based on the inflation adjustment, going from 12.9 to 13.61 million. So always preface this because, if I'm talking to you, there's probably a 99% chance that you're saying, geez, $13.6 million. Maybe if I win the lottery, I'll have a problem, but I just don't have that. But let me get through it because it does apply to some people. And it's, good to know anyway, just to make yourself a little smarter. $13.61 million in 2024 is the estate tax exclusion amount. Really, for married couples, it's each spouse has their own estate tax exclusion amount or estate tax exemption. Those terms are used interchangeably. Each spouse has their own. So really, married couples, and if they both pass away in 2024, they'd be able to shield the first $27.2 million of assets that they own from the 40% estate tax. So if you thought it didn't apply to you when if the exemption was 13.61, it's probably really not going to apply to you if you're married. And between the two of you, you can shield more than $27 million from the federal estate tax. Couple of upcoming changes worth noting are that here we are going into 2024. Then we're going to go into 2025 when the estate tax exemption amount will get another basis adjustment. It'll go up from 13.61 million to probably 14 million or 14 million and some change for 2025. And then because a tax reduction act that was enacted 8 or 9 years ago is going to sunset after its 10 years that it was in effect, then in 2026, the estate tax exemption is going to be cut in half, depending upon what some inflation adjustments are over the next couple of years. Probably be around 7 million and some change will be the estate tax exclusion amount starting on January 1, 2026. Unless, of course, Congress goes in and does something to change that. Years ago, when the exemption was scheduled to be cut, I think it was 10 million and was expected to go back to 1 million or 5 million. I don't even really remember. This was many years ago. Kind of late December, Congress said, well, let's just keep it at 10 million. And that really messed up a lot of people who did some significant gifting in anticipation of losing this $10 million estate tax exclusion amount. And then Congress just kept it there at the very last minute. But nonetheless, it is scheduled to be cut in half on January 1, 2026. So now that brings people who will have the $7 million estate in a couple of years. Maybe you have the $4 million estate now, and you're just an investor and you're frugal, and typical asset appreciation may cause you to go from a $4 million estate today to an $8 million estate, maybe 6 or 8 years from now. That could potentially be subject to the federal estate tax of 40% when you pass away. So quick note on what assets are subject to the tax. It's pretty much everything you own. So all of your, and some people mistakenly believe that it's the probate assets that are the only assets that are counted in the estate, or any asset that doesn't have a beneficiary on it. Those are the only assets that are counted for estate tax purposes. All those are false assumptions. If you have an ownership interest in something, it's going to be included in your estate, whether that's real estate that you own, including real estate that's in your revocable living trust. A lot of people set up revocable living trusts. It's not really a tax-driven vehicle. It's a vehicle driven to avoid the need for the court and attorney involved probate when you pass away, because things in your name when you pass away, they are frozen when you pass away, and then your survivors have to hire lawyers like me. We have to go through the court probate process. Judges have to sign court orders ordering these third parties, banks, financial institutions, to release the funds to the appropriate heirs based on the will that the judge approved. So many people, in an attempt to avoid not necessarily to avoid estate tax, but to avoid the probate, will create their revocable living trust, transfer their assets to it during their lifetime. That's key. So that when they die, the assets are already in their trust. They don't get frozen. They've named a successor trustee in their trust to be able to disperse those trust assets to the beneficiaries that were named in the trust instrument. So I say all that to let you know that assets that you own, assets that are in your revocable living trust, they're all counted as part of your estate for federal estate tax purposes. Real estate, homes, LLC ownership interests, small business ownership interests, S corporations, C corporations, publicly traded stock, IRAs that you own, 401ks that you own, life insurance where you have an incident of ownership. Most people do own their life insurance. There's some exceptions when you transfer ownership out of your name, where that life insurance death benefit could be not part of your estate, but that's another topic for another YouTube live stream. By the way, I've got a list of about 50 that I made the other day. If you have some topics that you like addressed on a live stream, put them in the comments. I'll add them to the list. All right, so all these things that you own, they're all, whether they're in your name, whether they're in your living trust name, whether or not you have a beneficiary designation because it's an IRA or a POD on a bank account, TOD on a brokerage account, all those things, if you own those things when you pass away, they're all part of your estate for federal estate tax purposes. All right, so there are some deductions that can reduce the value of your estate for federal estate tax purposes when you pass away. So, for example, let's say somebody died and you added up the gross value of everything they owned and it was $20 million. However, they had some debt. Maybe they had $5 million of debt. Well, that debt that someone has is a deduction from the gross estate. So now $20 million gross estate, $5 million of debt. Now we're at a $15 million net estate. But let's say they also left, let's call it $3 million to one or more charities, total of $3 million. The estate tax charitable deduction, that also gets deducted from the estate. So now we're from 15, we're down to a $12 million net estate. So those are big ones. The other big one is the unlimited estate tax marital deduction. So if a married person has a $50 million estate and they leave it all to their spouse, then their gross estate is $50 million. They left the $50 million to their spouse. Their estate got a $50 million estate tax marital deduction. So their net estate is zero. And we'll talk in a minute about portability and maximizing the use of both spouses' exemptions in a minute. But that marital deduction used properly allows married couples to make sure both spouses use their estate tax exemptions. And it also, the marital deduction allows married couples to arrange things so that there's never any federal estate tax due when the first spouse dies. It's only due if the estate is large enough after the applicable exemptions. It's only due after the surviving spouse passes away. And sometimes assets have to be sold after the surviving spouse passes away to create that liquidity in order to pay the tax, which is due in cash 9 months after the surviving spouse passes away on an estate tax return called IRS Form 706. Okay, so several years ago, the estate tax and the marital deduction was kind of revamped because something called portability was added. I mentioned that in the old days, if you had a married couple and they had $20 million, each one had $10 million. And if the husband died and left all of his $10 million to the wife and she had $20 million, sure, no tax would have been due when the husband died because of the marital deduction. But the problem was he didn't use any of his estate tax exemption. his estate got lumped into his wife's estate. And now when she dies, let's say she has a $7 million exemption, there'll be $13 million of assets subject to tax, the entire 20 million. So now with the IRS allowing for portability elections to be made, when the husband died, since he didn't use any of his estate tax exemption, his estate could have filed a federal estate tax return and made a portability election and said, husband's estate didn't use any of his $7 million or whatever it is, estate tax exemption. That exemption is now portable. Now, when the wife dies, she'll have her own $7 million exemption, and she'll have her predeceased husband's $7 million exemption that he didn't use. So she'll get to shield $14 million from the federal estate tax instead of just $7 million as it was done under the old rules. So just be aware that if you have some significant assets, maybe you're a married couple with $10 million or more and one spouse dies, but before you do anything, make sure you make an informed decision about the potential for this portability election. It's a big deal. All right, so that's the estate tax. Next, let's move into the gift tax. And actually, the estate tax and the gift tax are unified, as I'll explain here in a minute. But first, let me just give you some numbers. The federal gift tax, the annual exclusion amount is changing as we go from 2023 to 2024. It's changing from $17,000 to $18,000. Now, what does that mean? It means you can give $18,000. You can write people a check. You can give them stock. You can give them an interest in a company. You can give them an interest in real estate. You can give them a car that's worth $18,000. But you can give $18,000 of value to as many people as you want to every year without any what I'll call gift tax consequences. And we'll have to define what I mean by gift tax consequences in a minute. But just note that a gift is never subject to income tax. Many people mistakenly believe if I give my child or if I give so-and-so more than $18,000, somebody's got to pay some tax. And it really just isn't the case. So when someone makes a gift to someone else in excess of $18,000, they're just using up some of their, what in 2024 is their $13.61 million estate tax exclusion amount. Let me give an example. Let's say a father wants to help his daughter out, and she's living and she just moved to Tennessee, and she's living in Nashville, and she wants to buy a house. So dad says, you know what? I'm going to give you $318,000 to help you buy your first house. Probably didn't even cover the whole expense because housing is so expensive. So what are the gift and estate tax consequences when dad sits down and writes his check to daughter for $318,000? And daughter deposits that in her bank account? Well, the tax consequences are the first $18,000, no problem. He can give $18,000 to as many people as he wants to every year, but he didn't give $18,000. He gave $318,000. So what that means is dad just used $300,000 of his, and what in 2024 will be his $13.61 million estate tax exemption. So if dad dies in 2024, let's hope he doesn't. It'd be nice to see his daughter enjoy her new home in Nashville. But if he does die in 2024, instead of dad being able to have an estate or leave an estate worth $13.61 million free of the 40% federal estate tax, dad can only leave $13.31 million free of the 40% federal estate tax, because by giving his daughter $318,000 in 2024, he used $300,000 of his estate tax exclusion amount. Okay, so that's how the gift and the estate tax are, as we say, unified. Now, married couples, good to know here. If dad is married, married couples can each of the spouses can gift assets to as many people as they want to. So if dad and mom want to gift to their children, they can not only gift $18,000 because each of them can gift, they can gift $36,000 in 2024 to as many people as they want to without incurring any of the federal estate and gift tax consequences. So, if they have 4 kids and they have 10 grandkids, or let's say they have 4 kids and 6 grandkids. That's 10 people they could give to every year. And they could, as of 2024, they could move $360,000, give $36,000 to each of their children and grandchildren. There's 10 of them. And each year remove $360,000 from their estate, assets that will never be subject to the 40% tax. So they've shifted assets down to the children and the grandchildren. And again, after those assets are given away, if they're invested and all of those investments grow outside of the estate, all that future appreciation will escape estate tax as well. So a lot of wealthy people are doing the gifting and really maxing out the gifting without using any of the estate tax exclusion amount, and just shifting assets from one generation to the next. In addition to the $18,000 that people can give to as many people as they want to every year, in addition to that, maybe a couple of the kind of exceptions are, in addition to the $18,000 that you can give, you can also, if you want to, pay for the educational and medical expenses of someone. So let's say you had a grandchild going to school. You want to give them $18,000 because you can, but their tuition costs $50,000 a year. You know, if you were to give them that money and they were to use it for tuition, you'd be making what they call a taxable gift. You'd be using some of your exclusion amount. But if you follow the rules, pay the school directly, it's for tuition, then in addition to the $18,000, that's another $50,000 you can transfer for the benefit of your grandchild without any estate and gift tax consequences. So you can, if you follow the rules, and the rules aren't difficult to follow, you just got to follow them. You pay for those educational and medical expenses. That's just additional gifting you can do that a lot of people find helpful. Okay, so that's the gift tax. Number 3 of 4 issues that we'll address here is the capital gains tax. The estate and gift tax, they really don't apply to everyone. The estate tax applies to maybe 0.2% of the population, I believe. And the gift tax, well, there are people who aren't subject to the estate tax who are making gifts to people in excess of $18,000. So when you make a gift, you have to report that on a special IRS form, IRS Form 709. No taxes due. You just have to report that you made the gift. All right, now we roll into the capital gains tax, which is a big one. So, all right, the deal there is we just want to make sure everybody understands this difference between the step up in basis and the carryover in basis. One way to do that is with an example. Let's say back in 2002, 21 years ago, you bought some Amazon stock when it traded at 50 cents a share, because that's what it was back in 2002. Today, that stock is worth somewhere around $150 a share. So bought it 50 cents a share. Now it's worth $150 a share. Let's say you were to sell that stock today for that share of stock. You probably have a lot of shares of stock, but let's say you sell that stock for $150 a share. $149.50 of that is capital gain, all that appreciation since you initially purchased the shares of stock for 50 cents a share back in 2002. So you'd get smacked pretty hard with capital gains tax on the federal level, and depending on your state, perhaps the state level as well. So let's go back to the dad with the daughter. Let's say dad says, you know what, I'm not comfortable parting with $318,000 of cash because that gets me short on cash. So I don't want to give that much cash to my daughter to be able to buy a house. But he's like, well, I'll tell you what I do. I've got this Amazon stock I bought back in 2002. Why don't I just transfer $318,000 of stock into her name? She can use that to buy her first home. Problem with that is because dad, during his lifetime, gave or donated that stock to his daughter during his lifetime, as opposed to her inheriting it when he dies. I'll get to that in a minute. Because dad donated the stock, donated $318,000 worth of stock. Same gift tax consequence, $18,000, no problem. Use $300,000 of his exclusion amount. But because dad donated that stock to his daughter during his lifetime, his daughter gets what's called the carryover basis. So whatever dad's basis was, because he donated it to her during his lifetime, the daughter's going to get whatever his basis was, 50 cents a share. So if she needs to sell that Amazon stock in order to get the cash to buy her home, she's going to get smacked somewhere between probably 20 and 30% of capital gains tax, federal and state. And so that'll wipe out almost a third of that money. And that's not going to go over so well. So that's the carryover in basis. So whenever someone is contemplating making a large gift or transfer of assets to someone else, to children and grandchildren, there needs to be an analysis of, if it's not cash, what are you going to transfer to that next generation? Is it appreciated assets? And if so, you need to be aware of the carryover basis. Because if the daughter never, ever sells the stock and she just holds on to it until the day she dies, no problem, because then there'll be a step up in basis when she dies. But if the recipient of the gift is going to immediately turn around and sell that asset, then maybe donating an appreciated asset was not the most tax smart thing to do because of the carryover in basis. Now, let's say dad dies, and instead of dad donating that stock to his daughter during his lifetime, he dies, and all the kids each inherit some Amazon stock. That's where the step up in basis really comes in handy, because whenever someone dies, all of the assets in their estate get a step up in basis. If dad bought the stock for 50 cents a share, and when he dies, the stock is worth $150 a share, then whoever it is that's receiving or inheriting that stock will inherit it at the with a basis, and the basis being the value of the stock on the date that dad died, which means all of that appreciation just goes untaxed. So it's far better to inherit an appreciated asset than it is to be given an appreciated assets by someone during their lifetime. So be aware. Carryover basis, step up in basis, and a couple of other rules on the step up in basis. If you happen to live in one of the 9 or so community property states, then know that when the first spouse dies, even though dad and mom may have owned that Amazon stock as community property, which they probably did, when the first spouse dies in a community property state, all of the community property gets a step up in basis. Not if dad dies, not just dad's half gets a step up in basis, but all of the community property gets a step up in basis when the first spouse dies. That's a neat little advantage that people in community property states have. And then with the portability election that I referred to earlier, there's no disadvantage, at least from a tax perspective, of dad just leaving his 50% of the Amazon stock to mom. So dad dies, stock's worth 150, dad owns half, mom owns half. Let's say they have 1,000 shares. All of the 1,000 shares, not just dad's half, gets a step up in basis to 150. And now mom owns the entire 50 because mom had her half and dad left mom his half. And now mom lives another 10 years. And when she dies, the stock is worth $400 a share. Well, because dad left his half to mom and all of that stock is in mom's estate, then all of that stock will get another step up in basis, a double step up in basis when mom dies. So it used to be the first spouse to die should never leave anything to the surviving spouse, because the first spouse to die doesn't want to lump assets into the surviving spouse's estate to make the surviving spouse's estate too large for federal estate tax purposes. But now with portability, and now that the estate tax exemption of the first spouse to die is portable, and that exemption can be added to the surviving spouse's exemption, now structuring things a different way than we used to structure it is applicable in order to get what I call, and is applicable in every state, this double step up in basis. All right. And so be aware of that. All right. Let me go back and Go on to number 4. So one was the estate tax, one was the gift tax, next was the capital gains tax. Now, the tax that definitely applies to everyone, or just about everyone, is the income tax. All right, let's start with the basics. Generally speaking, an inheritance, an inheritance is not subject to income tax. There are some exceptions. But let's say your Uncle Moneybags dies. He leaves you $200,000. His estate writes you a check for $200,000. Sure, it was in Uncle Moneybags' estate for estate tax purposes, but let's say he didn't have a taxable estate. You get a check for $200,000. You don't have to pay any income tax on that. Generally speaking, an inheritance is exempt from the income tax. Now, there are exceptions. Probably the most popular exception is if you inherit as a beneficiary a traditional IRA or a traditional 401k. The owner of that IRA, while he was alive, he never paid income tax on that. If you're the beneficiary, when you get distributions from that inherited IRA, you'll have to pay income tax on those distributions from the IRA that you're inherited. But again, that's just one of several exceptions to the general rule. If you inherit a house or a car or a sum of money or shares of stock, you're not responsible for paying income tax on an inheritance that you receive. Okay, but there are some exceptions. The common ones, like I said, traditional IRAs. If you're the beneficiary of an annuity, there's likely to be income tax when you receive those funds as well. And quite frankly, if you do inherit some stock, and after you inherit the stock pays you dividends, of course, you'll pay income tax on the dividends or the interest on the savings account that you inherit $200,000. You put that in a savings account. Over the course of the next year, it pays you $8,000 of interest. Of course, you'll pay income tax on that $8,000 of interest, but you won't pay income tax on the inheritance. Now, also what I want to go over here is the kind of how income tax relates to trusts. A lot of misunderstanding there. I'll start with the general rule that trust income tax rates, trusts get slaughtered with income tax as opposed to individuals or married couples getting hit with income tax. For example, now I'm going to give you some exceptions here in a minute, and those are probably, the exceptions are probably more important than the rule. But starting with the rule, if a trust in 2024 has income in excess of $15,200, then that trust is going to pay trust income tax at the top 37% trust income tax rate on that income that the trust has in excess of $15,200, as opposed to a married couple filing jointly in 2024 doesn't pay income tax at the top 37% until they have more than $731,200 of income. So trusts pay income tax at the highest 37% rate on income that exceeds $15,200. Married couples filing jointly don't pay income tax at the top 37% rate until their income in 2024 exceeds $731,200. Okay, now let's get into some of the exceptions, because probably the most popular kind of trust that people create is the revocable living trust in order to avoid the probate. So the revocable living trust that people create all day, every day, all day long, thousands of lawyers creating these for people in an attempt to avoid the court and attorney involved probate when you die. Those trusts, essentially because the person who sets up the trust is still in control of the trust, they can do whatever they want to do with the trust assets, because they still maintain all of that control over their trust during their lifetime. That trust is what the IRS calls a grantor trust. And when you have a grantor trust, because the grantor, or also called the settlor of the trust, the person who set it up, sometimes called the trustor of the trust. Because that person is retaining all of the control and all of the benefits from the trust, it qualifies as a grantor trust. What does that mean? It means the trust is really invisible for tax purposes, and all trust income gets reported on the individual income tax return of the settlor or grantor or person who set up the trust. So let me give an example. Let's say somebody has $1 million CD, and just to keep it simple, and they set up their living trust. Let's say because they can get 4% interest on that CD, there's going to be $40,000 of interest produced in a year. So if they own that CD in their name and it produces $40,000 of income, they'll obviously report that $40,000 of income on their personal return. But let's say on January 1st, 2024, they transfer that to their trust, and at the end of the year, it's reported that that account produced $40,000 of income. Well, because their trust is a grantor trust, none of the tax stuff changes. They just report that $40,000 on their personal income tax return. Their trust doesn't file a return. Their trust doesn't pay any taxes because their trust is a grantor trust. Everything still just gets reported on their personal income tax return, just like it did when they owned it in their own name. But the big benefit is when they pass away, trust assets aren't frozen. The successor trustee, almost the next day, or perhaps as soon as he gets the death certificate of the settlor of the trust, he can go to the bank, disperse those funds to the appropriate trust beneficiaries without going through the burden, delays, and expenses of going through the probate proceeding. Okay, so be aware that yes, while trust income tax rates are high, I think I'm safe saying most trusts are grantor trusts, which means these higher trust income tax rates don't apply because all the income gets reported on the personal return of the grantor. Nonetheless, there are some complex trusts and trusts that accumulate income, and there are estates and there are trusts when people die that are subject to these estate and trust income tax rates. Okay, so my thing there, we've got the grantor trust and the high trust tax rates don't apply. Okay, so here's the deal on the taxes and estate planning is if you have a large estate, you need to know that we're kind of in a crazy situation now. And in 2026, January 1, 2026, the estate tax exclusion amount is scheduled to be cut in half. And the deal is if you don't use that $14 million exemption that you'll have in 2024 or 2025, if you don't use it by either dying, and I don't suggest you die to use your $14 million exemption, at least don't do that on purpose, but you could use it by gifting assets. And we realize it's only the kind of wealthy or super wealthy that can afford to transfer $14 million out of their estate to the next generation while they have a $14 million exemption. We'll see a lot of people doing that in order to use the exemption while it's so high instead of letting that exemption fall back to $7 million. And then, they can only shield $7 million either during their lifetime or when they die from the gift and estate tax. So the deal is some people ask, well, what if I give away, $2 million now? And the exemption, is $13.61 million in 2024, and it's going to be cut in half in 2026. Well, by making a large gift of, say, $2 million now, it really doesn't do you much good. If you die in 2024 or 2025, you'll have used $2 million of your $14 million exemption. If you die in 2026 and beyond, you'll be using $2 million of your $7 million exemption. So you don't really gain a significant benefit by making a large gift now, unless that large gift exceeds the amount that the exemption is going to be cut back to. Okay, so anyway, if you have questions about that, you can put them in the chat. But if you have a large estate, know that that's coming up. If you have just a kind of middle to middle upper class estate, you're like, I'm never going to be subject to the estate tax. Not something I have to worry about. But if you're married, probably worth putting some effort into making sure that this double step up in basis occurs. And not only does appreciation up until the first spouse die go untaxed, but also any appreciation from the time the first spouse dies until the surviving spouse dies, structuring things so that assets will get that double step up in basis and the whole marital estate will get another step up in basis. That surviving spouse could live for years or even decades after the first spouse dies. There could be a significant amount of appreciation, and to get that double step up in basis and avoid capital gains tax on all of that appreciation, that's about the only tax break we have left in estate planning these days is the step up in basis. People who have never heard of it are even kind of surprised that it exists because it's really a tax break. Yes, there's been some lingering talk out there about eliminating the step up in basis. It would create accounting difficulty, and in my view, that's just kind of talk right now. Nothing serious happening in that area. Okay, so what I want to do now, first of all, I want to, before I go to the chat, I want to thank all of you for joining in. I want to encourage you to do a couple of things. One, go to my YouTube channel and click on the live tab. You'll see a schedule of upcoming live stream presentations that I'll be giving next week. And I'm going to add to that list because I have a long list of topics I want to address. And then also, anyone else who could benefit from this kind of information, feel free to just share or forward the information on the YouTube live streams to them. And my goal is just to get as many people out there in America as we can to make informed decisions, to make this process easier on themselves, easier on their survivors, easier on their children, their grandchildren, avoid all as much of the difficulty and family conflict as we can. My quick story, when I was 8 years old, my grandmother passed away. My grandfather worked for Humble Oil. And so I was able, when I was 8 years old, to inherit a few shares in what is now ExxonMobil, and sure did make it easier for me to go to college, to go to law school, to get my, earn my master's in tax law, to get started, on my life. And now, my wife and I have 5 kids, 3 are lawyers, 2 are in law school, and away we go. So it kind of estate planning has always been a part of my life because I lived through it and saw the benefit of when it's done right. And then through 30 years of practice, I've seen my share of nightmares as well when people either don't do it right or there's family conflict, and really an inheritance in some cases does more harm than good. Okay, so let's jump over here and see what we have on the chat here. So let me go up to the top. Got some folks here. Okay, thoughts on unmarried senior singles, use of Medicaid compliant annuities as asset protection from long-term care estate recovery in long-term care planning versus zero. Okay, so, obviously this live stream had nothing to do with Medicaid planning, making yourself appear destitute to the government so that you have less than $2,000 of countable resources and the government pays for your nursing home expenses is the general idea there. Married couples, sometimes they have too many assets or too many countable resources, so they convert those resources into an annuity, which can help if the annuity is paid to the spouse who is not in the institution but is still living at home in the community, called a community spouse. And so there's so many factors that go into that. I don't want to dig deep into that. I will do some live streams on some aspects of elder law and Medicaid planning, but right now we're just too much to go into whether that's just generally a good idea or not a good deal. But at least I acknowledge the question, which is about as good as I can do right now. Please keep in that some states, in mind maybe, that some states like New Jersey have extreme death taxes. Yep. So a lot of states have a few states, less than half, have their own estate tax the estate, or an inheritance tax, which taxes the recipient of an inheritance. People with children pay nothing. People without children or spouse get crushed. So yes, that inheritance tax, which is a tax on the heir or beneficiary who received an inheritance, their tax is based oftentimes on the relationship they have to the person who left them the inheritance. So the tax on a spouse who's inheriting, or a tax on a child who's inheriting, or a tax, or something left to a charity is far less, or oftentimes doesn't even exist. But the tax when it's left to what I call a stranger or unrelated persons, when I say stranger, I don't mean person you don't know, but a non-related person, that inheritance tax can be in the range of 10% or more. So some of the same gifting rules apply on avoiding the estate or inheritance tax at the state level. So, that is a big deal. Thanks for pointing that out, Paul 60. Great first name there. Let's see. More in New Jersey. There's a 3-year look back to capture money given away in previous 3 years. No way out except, So, we've talked to people who have moved out of their state because they don't want to die in their state and have the applicable state, estate, or inheritance tax apply. So they'll move to one of those states where there is no inheritance or estate. And my guess is there's probably maybe, I'm just guessing here, maybe somebody can correct me, maybe 8 states that actually have an estate or inheritance tax, around 42 or so, and I think it's around 40, that don't have their own state, estate, and inheritance tax. Keep in mind what we talked about during this whole live stream presentation is the federal estate tax that applies wherever you live. All right, risk capital. For those of us who live in states with an estate tax and have an estate above the state's exemption amount, what do you typically recommend? Just move to a different state? Yeah, I mean, that's an option, but geez, I hate to see people uproot their entire lives because of tax purposes. So if you're thinking about moving and you want to move and you can get as an extra benefit avoiding the estate and inheritance tax, by all means, take advantage of it. But I hate to see someone who likes where they live and lives around family and wants to be in around their family, hate to see them lose that proximity to their family just to try to avoid an inheritance tax. So some gifting, and another commenter wrote about the 3-year look back rule. So you got to start early and you got to start often. So essentially the strategies to avoid state tax are similar to the strategies to avoid estate tax. Now the tax rate at the state level is typically not as confiscatory as it is at the federal level. The federal estate tax is 40%, but you have a $13.61 million exemption. The state, for those states who do have an estate or inheritance tax, the exemption levels are typically much lower. Okay, back to Pear Valley 1, back to leaving stock when you die. Which amount of the stock comes off the lifetime estate amount is applied? Basis or appreciated amount? I'm not sure if I'm answering your question, but the federal estate tax is based on the value of the assets on the date that you died. So if you owned a whole bunch of Amazon stock and it was worth $150 a share on the date that you died, that's the value for federal estate tax purposes. And that might be answering your question right now. You don't back out some kind of previous appreciation or anything like that. So federal estate tax, value of the assets on the date that you die. If those shares go to someone and they later sell them for $180 a share, they were worth $150 on date of death, there'll be $30 of capital gain that will be subject to the capital gains tax. So some people ask, what do I have to do to get the step up in basis? Do I have to put those assets in a will? Do I have to do those assets have to be in a living trust? Do I have to report the value of, do the value of the assets have to be reported on the date someone dies in order to get the step up in basis? Answer to all those questions is no. It just happens automatically. If when you die, you own assets, whoever gets those assets, the basis will be the value on the date of your death. There's nothing proactive someone needs to do in order to capture the step up in basis. All right. Mary Kay Dragovich says, I have no children. How can I leave nephews my estate without major tax consequences? So the answer there is, if I would say, what's the value of your estate for federal estate tax purposes? Is it anywhere near the $13.61 million estate tax exemption? Is it near the $7 million exemption that will be around $7 million in 2026? For federal estate tax purposes, the strategy is the same, whether you're leaving it to children or whether you're leaving it to nieces and nephews. The tax is the same. So let's look at federal estate tax consequences. And then secondarily, let's look at what state you're in, see if it has an estate or inheritance tax. If it does, is the inheritance tax higher because you're leaving things to nieces and nephews, or nephews, as you say? So, and then again, do you want to do some gifting or set up some trust for them to start moving some assets into either their name or into trust for them before you die to avoid any potential state, estate, or inheritance tax? Okay, good. I'm glad that's what you wanted to know, Pear Valley. Good, cool, brother G. Is the capital gains tax different if one spouse is disabled? No, it's going to be the same there. But it's Apple. Okay. Pear Valley one says it's Apple, not Amazon. Yeah, I was working with a gentleman just a couple of weeks ago who he bought back in the 80s, bought Apple stock, and we talk about it every time I talk to him on our Zoom calls. And he owned a bunch of shares, many tens of thousands of shares, and it was all I believe the Apple stock is worth today somewhere around $194, $195 a share. He talks about it all the time. So he bought it for pennies on the dollar back in the day, and it virtually makes up his entire estate is Apple stock. And so big deal there on appreciation. And now I will say one area where he was confused was that if you own that stock inside of your traditional IRA or your traditional 401k, there's no step up on assets inside of an IRA. So if you have Apple stock inside of an IRA, now if the stock is sold inside of the IRA, there's no tax consequence then. But as soon as that money is distributed to the IRA owner or the IRA beneficiary after the death of the IRA owner, those distributions are going to be subject to ordinary income tax. So there is no real step up in basis for assets inside of an IRA. Just kind of keep that in mind. Okay, great YouTube live stream. I've got some scheduled for next week, starting Tuesday, and feel free to check out those. And I hope everybody here has a Merry Christmas. Thanks for your comments. Thanks for your chat. Thanks for sharing your experiences. We'll see you next time.